Hello, everyone. Welcome back to another episode of the Public Law Parlour. This is season 1, episode 4, since we have launched this podcast. We want to thank you all for staying with us, for supporting us, and for following us. Don't forget to like, share, and subscribe to our YouTube videos. Again, I know that we had quite a bit of a hiatus since you last saw something from us or heard something from us, the last installment. And that is because, as usual, professional duties call. And of course, I have my co-host, Alex, here with me, who can attest to that. It's very difficult to get him on a podcast these days because he's flying all over the region and appearing before all of these different courts for these public law matters, some of which we will be discussing in future episodes of this podcast. Alex, you have any words for our followers?
Hi, everyone. I'm very happy to be back for episode 4 of the Public Law Parlour. And I would like to state for the record that I alone am not the only busy person here, and that this podcast would not have been happening had I not asked Rico or told Rico that we will record a podcast on this case, just for the record.
Right, so let's get straight into it. So, of course, there's always something happening within the public law realm in the Caribbean and outside of the Caribbean. Today, we're going to focus on a public law issue, specifically constitutional, that is directly related to Caribbean constitutions. And today we have a guest with us, a very illustrious guest, if I might add. He is no stranger to podcasts. As a matter of fact, when I first had my initial podcast called the CARICOM Public Law Podcast, he was one of the first guests that I invited. Me and my former co-host, we invited on that podcast as well. And he's here again. You just can't get enough of him. You can't get rid of him because he is just too good to be kept in the background. He is also no stranger to panel discussions. He's also no stranger to presentations. He just came back from the University of Oxford, where he was doing a very riveting presentation on decoloniality and Caribbean constitutions. That's his niche area right now that he's taking control of in the Caribbean academic space. And we are, of course, speaking of no other person than Dr. Ronnie Yearwood. Dr. Yearwood is now, and we must congratulate him. Join me in congratulating him, as he was just promoted to senior lecturer in law at the Faculty of Law at the University of the West Indies. Congratulations, Dr. Yearwood. He's also the deputy dean, one of the deputy deans in the faculty. And from here on out, I will just call you Ronnie. Because, you know, this is supposed to be an informal setting, and we are both familiar with you, both Alex and we are familiar with you. So we're just going to call you Ronnie. Remember, guys, this is a podcast dedicated to casual, operative word being casual, conversations about public law. And before I go on, let me just say, because a lot of people usually ask this question, as far as I'm aware, we are not related. We're not brothers, we're not cousins, we are not relatives. So many people approach me and ask me, is Dr. Ronnie Yearwood your brother? Are you a cousin? Are you all related? And I tell them, as far as I'm aware, he's not, but you never know. So let me just put that out there. So Ronnie, welcome. Glad to have you here.
Thank you. I don't even know what to say after all of that. Thank you very much, Rico. Thank you, Alex, for having me. And Rico, I just said you never know who step out. As you was saying in the Caribbean. So you can never tell. But thank you guys for having me. I've been following your podcast, and as usual, You produce excellent work that is important for the region and for jurisprudence and constitutional discussions. And these kinds of activities are great for providing space for emerging scholars and for more senior scholars, and just spaces so that we can discuss and dissect and unpack some of the issues facing the Caribbean in terms of its constitutions and public law issues, which are obviously important for everybody, and they kind of set the context sometimes for larger political, social, economic discussions of where the Caribbean is going, or what we must do to ensure the development and the continued survival of the Caribbean and its people. So thank you for having me, and looking forward to what should be a really interesting discussion.
Thank you very much, Ronnie. We are excited to have you here, and this would be a good time for me to discuss or segue to the topic of today's discussion, which is the recent decision of the Privy Council in the Corporation of Hamilton against the Attorney General of Bermuda. Now, this case is important because it represents a continuation of the ongoing debate between the Caribbean Court of Justice and the Privy Council on the approach to the enforceability of opening sections. To provide some context before we go into the details of the nuances of the law, the Corporation of Hamilton against the Attorney General of Bermuda arose from a challenge by the Corporation of Hamilton, which is a company established to manage the city of Hamilton in Bermuda, alleging that the recent amendment, Section 7AA of the Municipalities Act and the proposed Municipalities Reform Bill violated their rights under Section 1 of the Constitution, particularly their rights to protection of the law and their right to arbitrary deprivation of property. Section 1, as is quite evident, is the first section of the Bill of Rights in the Bermudan Constitution. And one of the primary issues that the Privy Council had to address in this case was whether Bermuda could enforce this section. Now, segueing on to the first question, for listeners who might not be too acquainted with constitutional law, could you both please explain what are the opening sections in Caribbean constitutions, and why is there so much controversy on the enforceability?
Okay, Rico, do you want to go? Or?
No, Ronnie, the podcast is yours for today. You're the expert guest, so
oh dear. Why?
What you have to say.
So when you think about Caribbean constitutions are a little bit unique, as some folks would know, and those who don't, in that there are two preambles typically in Caribbean constitutions. There's the preamble that you would find at the front of the Constitution, if you want to put it that way, where it usually starts, we the people of whatever, Barbados, Guyana, Trinidad, Jamaica, and it usually expresses broad aspirations in political terms about independence, or sometimes the Bahamas preamble tells a story of the country. Some preambles, I think, are I could say, slightly offensive in that they do not address the coloniality of the country. And sometimes when you read them, for example, the Barbados preamble stands out. It does not tell the story of the people. And you would read the preamble and you would not understand that the country had gone through a period of slavery, colonialization, and then a kind of decoloniality with independence, because the preamble reads as if the beginning of Barbados was by some gentle experience and harmony between the British settlers and, at that point, the African persons who were brought here and obviously enslaved to create what Hilary Beckles promptly calls the slave society, different from a slave-owning society in that slavery perpetuated all aspects of the society, from economic to reproductive health rights to social experiences to labor, to everything. Everything was built in through that slave experience, or that idea of slavery running through the society. So you have that preamble at the front of the Constitution. All Caribbean constitutions have this. And then when you get to the Bill of Rights, there is another preamble which opens and introduces the Bill of Rights. Again, it would contain aspirations, setting out the nature of the rights and what it's about and what the rights are supposed to do. And then it continues and sets out the very specific detailed rights afterwards, in the subsections. So often it would talk about, and so since we're talking about Bermuda, let's draw from that. The Bermuda one says, whereas every person in Bermuda is entitled to fundamental rights, freedoms of the individual, that is to say, a right, whatever his race, place of origin, political opinions, color, creed, sex, etc., but subject to rights and freedoms of others and for public interest to each and all of the following, namely life, liberty, then it goes on freedom of conscience, expression, assembly, protection for privacy of home, property, and then it goes, the subsequent provisions of this chapter shall have effect for the purpose of affording protection of aforementioned rights, and then it continues to list a whole set of other rights, protection for slavery and forced labor, arbitrary arrest and detention, provisions to secure protection of the law, etc., etc. So you would have that that other preamble, if you like, in the Constitution. So typically, as I said, Caribbean constitutions would have these two sets of preambles. You have the broad preamble at the beginning of the Constitution, which usually sets out general aspirations of what the Constitution is supposed to be. And then you would have this second preamble, usually preceding the Bill of Rights, broadly setting out the rights associated or afforded to persons. The controversy, I think, comes from the enforceability or the justiciability of these preambles, because there are some schools of thoughts that would say preambles are as they are, they're introductory languages, they don't have the force of law. Others would say no, preambles are actually more than simply introductory clauses, and even if they don't have the direct force of law, they can offer interpretive guidance, or they can provide context for enforcement of subsequent provisions. So you have really two schools emerging about how we think about preambles, and we'll get into more of the discussion about nature of preambles and such like, and what preambles can do as we proceed. But that just kind of sets up, broadly speaking, what we are facing in terms of preambles here. I don't know if you have anything else to add, Rico, or if you want to jump in now.
Yes, I don't have anything to add, Ronnie. I think that you set the tone or the scene perfectly with that one. You said everything that I would have said, and I'm glad that you were able to acknowledge, whether wittingly or unwittingly, that the opening section is a preamble. Because by acknowledging it as a preamble, it seems to suggest, or you are seeming to suggest, that it really should not be, but be justiciable. Whether or not that's actually your view, you will tell us later.
Well, let me just say it is not my view. Because it is the opening section, I don't think that it is not justicable. I think actually that preambles are justicable, and I would put it, people can make this a very complex issue, but for me, I think what you have to do when you drill down on it, my viewpoint is, you've written it into the law, you've put it in the context of the Constitution, which is the supreme law. If you don't want it to have force of law, or you don't want it to have meaning or give context, well, don't put it. That might sound like the most non-lawyery thing to say, but the reality is, if you sat down and you took all of this time to create these principles that should guide the society, and then you're going to tell me that these principles, these lofty high principles about justice and rule of law and rights and protection of the environment and allowing people to have a say in assembly, all of these things, all of these aspirations about creating this just and this good society that we want to form, as a kind of repudiation of coloniality in terms of independence. And then you're going to look at me as an ordinary citizen and say, you know what, you don't have access to those. Those are just the opening statements, but really they don't mean anything. Well, that makes no sense from a kind of just operational point of view. And that's why I struggle with the logic of sometimes folks who would say, you know what, these preambles are just there, but they don't have force of law. They don't add anything of value to the Constitution or to the Bill of Rights. So I'm like, well, then why did the framers and the founders, why would you take the time to frame? And some of these preambles, as you can see, are framed with precision. So somebody must have had reasoning by establishing, one particular principle in the preamble as against some other principle. Because by inclusion, often you exclude something. So somebody, when they sat down, thought very carefully about what they were saying when they were trying to frame these preambles. So if you put that effort in, there has to be some, if you like, context or some ability to make use of those preambles. And maybe because too, I also come from international WTO background as well, where this debate of preamble language has raged on for a while. I think we've more or less settled that the reality is, the preambles do provide context. They do give you that kind of principle, give you broad principles by which you can apply the law, which is really important because sometimes the hard law you get in the text needs something to drive it. It kind of needs oil for the machine. If so let's break it in that layman's terms. If you want to think about that, you can think about preambles as oil to the machine. The machine is the hard law, and every once in a while you need something. You need that grease to just get it going. To make sense of what this hard law is saying, let's go back to those aspirations that the founders would have expressed.
Okay, quite interesting. And anyone who knows Ronnie well would know that he's quite known for having excellent analogies, just like that one that he created. I really love that one where you said that the preambles are like the oil for the machine being the hard law and the other detail and substantive sections. Not that I agree with your position about opening sections, but I must admit it's a very good analogy. Now, Ronnie, let's first look at the CCJ's position about opening sections. Now, the first time the CCJ had to consider whether opening sections in Caribbean constitutions are actually enforceable or justiciable was in the seminal case of Attorney General and Joseph M. Boyce. And for our followers, you would notice that since this podcast was launched, we mentioned this case in almost every single episode because, like I said in the first episode, this case is so important and fundamental to Caribbean constitutional law. So don't be surprised if you hear the name of this case in almost every episode going forward as well. But that was the first case where the CCJ had to consider the enforceability of Barbados's opening section, which is section 11 of the Barbados Constitution. Now, quite curiously, what the CCJ said at that point in time is that, well, the right to protection of the law in that section 11, which is the opening section, is enforceable, right? Because of its connection or linkage with the detail section related to protection of the law, which was section 18. But that was as far as the CCJ went. The CCJ said just that particular right to protection of the law in the opening section was enforceable. It didn't consider the entirety of section 11 to be enforceable at that point in time. Slightly over a decade later, we have the case from Barbados again, Nervais, and the Attorney General, and now the CCJ is being called upon to address the issue of the enforceability of the entirety of Section 11, that opening section. And quite curiously, again, we see that the majority of the CCJ slightly deviated from their reasoning in Joseph and Boyce, because they're now saying that, well, look, it's not just that right to protection of the law in the opening section, Section 11, that's enforceable, but Section 11 in its entirety, that entire section is independently enforceable. That's what the majority said. But you had the minority, and the minority was really and truly only one judge, who, quite interestingly, is now the president of the Caribbean Court of Justice, Justice Winston Anderson. And he said, no, we cannot consider the opening section, this Section 11 in Barbados's Bill of Rights, to be independently enforceable, because that was not the intention of the drafters of the Constitution. So to just lay that foundation about the CCJ's position, I'm going to ask you this question now, Ronnie. So bearing in mind what the majority of the CCJ ruled about the enforceability of opening sections, can you please tell our viewers, our followers, what was the reasoning behind the majority's decision, and how does it fit into the broader philosophy of how the CCJ interprets Caribbean constitutions? And if you so desire, you could also, give us some thoughts about, Justice Anderson's dissenting opinion as well.
Well, I think, okay, so, all right. I think you're trying to set me up here, Rico. but that's okay. That's okay. No, I think what the CCJ was getting at, and it makes sense if you sometimes you have to see decisions or judgment as a continuity. I think sometimes often we see when judges do, and this is something that's fascinating me in my research now about judges making law, which you would know. I think we see judges sometimes as these kind of Herculean beings who can't change their mind, who, when they get supposed to be right the first time, and then they do something slightly, as you see it as a deviation rather than a development of thought. Because sometimes when you're faced with a decision, at that point in Joseph, you say, okay, you know what? It's just that section. Then you get to Nervais, you're like, okay, actually, you know what? Maybe 10 years, whatever, the whole section actually becomes justicable. And I think sometimes maybe our approach in academia to judges creates the fear for them to have that developmental process in thinking, because they don't want to be labeled as deviating or changing their mind, as if, you know what, you can change your mind, because the research may be different, the context may be different, societal values have changed, and why shouldn't we afford them the ability and the room to say, it is okay for you to say something in Joseph, and then actually in a way say something slightly different, because you recognize that the court has been growing, the law is changing, and we need to give more enforcement, or we need to give wider access to those values and to those principles that were in the preamble. And if you think about it, sometimes the Caribbean constitutions, the rule of law is established in the preamble. And that's the only way you can reach into it, because there's no particular rule of, section going like, here are all the principles of the rule of law. And we find it expressed often in our preambular language. And that's how we reach into our constitutions to kind of drag it out and say, you know what, come out here, stand front. You need to come front and center, because we need you to operate to provide for the context, whether it's a case against the government or protection of rights, whatever we need to do, we need to come front and center. So I don't see it necessarily as a deviation, perhaps so much as a development of thinking in terms of what the court was trying to do. Now, in terms of Justice Anderson's position, it's interesting, and this is something. This is a, how do I put this? I want to frame this correctly, because this is interesting in that the Privy Council has weaponized And they obviously knew what they were doing because, as I said, judges make law, they don't understand nuances of political context. They're clever people. They have weaponized the current president of the Caribbean Court of Justice against the Caribbean Court of Justice through a Privy Council judgment distinguishing and differentiating what preamble should do in Caribbean law. And it is so interesting for a court that often says that it wants to get rid of the Caribbean from brain judgments up to them. And we know some of the previous heads of the Privy Council said this, when is it, why do you keep coming to us? But here you have, and this is why this case is so powerful. I don't even know if people are recognizing what they do. And maybe that's just because I'm wearing my political hat. So I'm looking at the political power play here because they didn't have to. You didn't have to reach in to use the very words of the man that you know that will become the president of the Caribbean Court of Justice to make your point, to denounce the preamble, because they know exactly what they're doing. You know exactly what you're doing. So you are creating a political rift now, or you're trying to put a wedge in between the approach of the courts as a majority and the person who wears the hat as the president, who's supposed to, project the view of the court. And they knew what they were doing because look when you look at paragraph, because they quoted this entire paragraph. So when you look at paragraph 70 of the Hamilton case, they quote his dissenting. So let me just try to unpack his reasoning. And they go Anderson, Justice Anderson dissenting in Nervais did not accept the reasoning of the majority, which you just explained, Rico, in terms of they moved from the narrow view to the whole of Section 11. And he goes, and this is what Anderson says. What clearly emerges from this underlying structure is that Section 11 of the Constitution was not intended to be enforceable. He goes on to say it is preambulary declaration of rights and freedom, which refers to the section explicitly states that the detailed provisions shall have the effect afforded. So he's using the literal meaning of the words. And if you've ever followed Justice Anderson's judgment, you recognize he is a good, what I would say, old-fashioned black letter kind of lawyer, doctrine. He always seems to, what do the words say? Not what does the philosophy, what does the context. I want to know what the words. And that's what he says. He goes here, the section explicitly states the very detailed provisions which follow, and he puts the terms, shall have the effect of affording protection. So he's looking at the words, and he goes, Section 24 was framed on the understanding that only breaches of Section 12 to 23 would attract the remedy. So not the Section 11, which in Barbados context was the actual preamble and language. So for this reason, Section 11 is omitted from the remedy provisions, and the rest of it. So, and then the Privy Council, that's what they did. So whole paragraph dedicated to what Anderson said. And then in paragraph 71, they go, Justice Anderson stated at paragraph 82 that the propositions form the unstated premise of several past decisions of the Privy Council. So now they've got the president of the Caribbean Court of Justice put in words through him to say that his propositions form the premises of the Privy Council. full well knowing that at the moment, the Caribbean Court of Justice is doing what? Celebrating 20 years, and we are in the process, and this is why I said this case is interesting from so many angles, and we are in the process, really, of not only 20 years of the court, but if you think about it, it is a process of decoloniality that has been continued, and it's something that we should be proud of, because often when you talk about decolonization, the court is seen as one of those practical steps that you take into that process of decoloniality. And I would, okay, I don't want to impute improper motives because we're all counsel and colleagues and lawyers, and we're all trained not to do so. But at the same point, you cannot shy away from the reasoning. Why would you do this in a judgment, knowing full well where you cannot be oblivious to where the Caribbean Court of Justice is. You're not oblivious to its work because you do quote its work. You do quote the understanding. This is what the Privy Council is doing. They know what the court did in Joseph. They know what the court did in Maya Alliance. They know what the court has been doing in McEwen. They know the court has been using these preamble languages to kind of dismember the coloniality of constitutions, to erase the savings law clauses, to introduce the new rights that that we want to give our citizens, to build this new political identity. You're clear because you go through your entire judgment saying, yeah, I'm aware. The Privy Council makes that point. We know what the Caribbean Court of Justice is doing, and then for good measure, you rub salt in the wound by choosing the dissenting opinion of the person who is now heading or to project the next 10 whatever years for the court, because we have to recognize this, the court as an agent of decoloniality, because that's what the court is. However we cut it, that's what the court's doing. The court actually asserted it as its mission 20 years ago. The court was like, yeah, we know we're here to do Caribbean jurisprudence. We're here to decolonize. That's our purpose. So there's so much tension in this Hamilton judgment, and I don't know if the board was waiting for a moment to critique the Caribbean Court of Justice, and this kind of gave them the opening, because I would think the folks on the board are too clever not to have realized all the things I've just said, because there's no way you would sit down and write this judgment and not have all of these things flowing through your mind. These are clever people. They are trained lawyers. They've been doing this for a long time. They understand nuance. They understand turn of phrase, that one word and one, direct colorful word can change the whole meaning. And so I think there's so much here for us to unpack on what the Privy Council just did, and what they're signaling, because they're making it clear, I guess, that there is a competing jurisprudential force in the region that is setting down its stakes. This is our position. We are not going to move from this view about preamble language. And actually, to make matters worse, or just so you know, excuse me, your president agrees with us. So there, think about that.
So now segueing, I must say I actually agree with you wholeheartedly, because I think it is emblematic of, I guess, a jurisprudential not rift, but a difference in values that you see coming to light, and the colonial mission of the CCJ now running up against the established colonial strictures of the Privy Council. And I think you're right when you say that you see this in this judgment a lot, because in Hamilton, the board was very clear to reinforce the black letter law of interpretation, even in constitutions, where they they um they emphasize that the specific wording of these provisions. So if you look at the word, they looked at the wording in the Jamaican Constitution, where similarly determined that the whereas provision was not enforceable.
Mm-hmm.
Similarly in Malta, in Oliver and Buttigieg, in Dominica and Blomkist and the AG, where they have maintained their position that in spite of the sui generis nature of these provisions, you need to pay particular attention to what the words mean and the grammatical intention behind these provisions. So much so that actually in Mauritius, in the Society Union Docs against the government of Mauritius, the fact that they use the word "it is hereby declared" in their mind meant that opening section was enforceable based on the minute distinction between whereas and is hereby declared. And I think what we would like to hear from you is what is the broader philosophy behind how the Privy Council interprets constitutions, and what does this judgment represent in terms of the way forward in which what the countries that still subscribe to the constitution, what can we expect, or what does it represent from them?
I think this judgment is really and you're right. I think this judgment is really a signal um uh to the countries that are members of the Privy Council that we are different. Our mission is different to what the Caribbean Court of Justice is. And if the countries that have not joined the Caribbean Court of Justice are unable to see that through this judgment, that speaks to other broader issues that we would have to address in terms of what is our decolonial mission, what is the purpose of the Caribbean identity as a collective identity, and then what is the purpose of the Caribbean identity on an individual country basis. So, what does it mean to be Barbadian? What does it mean to be Trinidadian? What does it mean to be Jamaican? What does it mean to be Guyanese? Yes, all that. But then what does it mean to be Caribbean? What does it mean to be of this collective, these group of people, these group of islands that we call the Caribbean? Because here you have the Privy Council making it very clear that they are bound to these very narrow interpretive approaches, and they're not departing from it. I was just trying to find the section in the judgment where they say that much. We've gone through this, and this is our position, and we're holding to it. We and what has me is they go. We recognize that the Caribbean Court of Justice is doing something different. And interestingly, in the judgment, and you guys can tell me, I didn't get a sense that they wanted to even engage with what they recognized, they acknowledged, but they didn't engage with it in any kind of deep sense to say, okay, this is why we are different. It was almost a very matter of fact, look, you know what?
Yeah, that was paragraph 65, yes.
Yeah, this our precedent is such. We know what you're doing, but hey, this is what we're doing. So you either are with us or you're not with us. And those with us, we are telling you clearly, we're signaling to you without any room for misinterpretation that maybe they're thinking about it, maybe they'll have a liberal kind of wide interpretive approach to preambles, which would give marginalized groups rights, or groups that have never had access to justice. Maybe they didn't leave any room for maybes. They made it clear these preambles don't have meaning for us. They're not enforceable. They're not operative in our constitutional setup in the way that the Caribbean Court of Justice sees them. Let us move on. And they're not for this reason because of our precedent, and we're not changing it. Simple. There was no nuance. There was no maybe they're leaving the door kind of open. Some of these judges do that. They'll say something and then they'll say something to give it a little context or to create room for exception in the next judgment. Judges are clever. We know they do that. You've got a case, you're not so sure, you want to leave the door open just in case a similar case comes up. You can expand the exception that you may have created, and you can always lean into what you said. I said X and Y in this case, and therefore, I can see that there's room for me to change my mind, if you like. So they create that avenue for changing their minds. Here, I don't think they did that. I don't know if you guys, I can't see that they kind of, it was pretty much laying down the gauntlet. Boom, this is where we're at. That's where they're at over there on the other side. So pick a team, pick a side. Do you want the narrow, restrictive, sticking to precedent judgments of the Privy Council, or you can go over there for the kind of liberal, open judgments of the Caribbean Court of Justice, and its decolonial mission. They didn't
Yeah.
mention the decolonial mission, but obviously you can't talk about the Caribbean Court of Justice without talking about its decolonial
Yeah.
mission, which I
You also
guess
can't you also can't talk. I think I agree with you because they were very clear to highlight the Maya Alliance decision, Nervais, and
yes,
all of these cases form part. Lucas as well. All of these cases form part of that larger decolonial mission and the derogation from established principles. Well,
correct.
previously established principles of constitutional law.
Exactly. That's why I said they
Yeah.
knew what they were doing.
Yeah.
That's why we read this judgment. It is clear because you're right. All the cases that they mention, we know are seminal judgments that anybody writing about the Caribbean constitutional law, when you mention these cases, you are really talking about cases that are departing from coloniality, departing from trying to erase the Savings Law Clause, trying to provide new rights. We know what these cases represent for Caribbean judgments. So the fact that they mention them and then go on to say, well, actually, this is where we're going, they are telling you that that's not their mission. That and I think there has to be an acceptance of that. Anyone doing this for a while, we know that there's no and I said this in a recent paper that we can't expect the Privy Council to be a decolonial court no more than we can expect the Caribbean Court of Justice to be a court of English constitutional law. I mean, each particular court comes with its mission. It has its own universe that it's trying to build and a universe that it was defending. So when I see the Privy Council doing what it's doing here, you can't be upset with them because that's their universe. What else do we expect them to do but defend their presidential, what they set as their precedent? Do we expect them to wake up and go, yes, preambles are despicable and we now recognize it and we are going to dispense with years and decades of judgments just to accept that this new court, 20 years, new kid on the block, doing amazing things, um, being so creative, being so innovative with its judgments to give them room. Do we really expect that the Privy Council would do that? I mean, anybody who would think that would have to be living in an alternate universe of their own creation because there's no way they're going down that line. And in this case, shows that. So as much as there may be collegiate respect for judgments emanating from either court, it's clear from if it wasn't clear before, and it's always been clear, what the mission of the two courts are from this case. This case almost reads like a mission statement for the Privy Council. At least when you have businesses, we call it, when you do over your mission statement, like a refresher, and you just want to be clear, this is you brought the team leaders together, you say, this business has been going on for about a good 100 years or whatever. Let us refresh our mission. What are we doing? And this case reads like that. And it's interesting that they also were clever enough or clear enough to set out the mission of the CCJ. If you read between the lines, they're telling you that's their mission. This is our mission. Two complete different approaches. Um, and as I said, pick a side.
Yep. There's a very clear gauntlet laying down. It's like people of the Caribbean choose where you want your
Yeah,
judiciary to go.
yeah, exactly. And as I said, in this recent article I did, and I said, whose stories are these courts telling? So if you want a court to tell your story of a decolonial mission of a people trying to assert their identity, trying to create new rights or at least enforce existing rights, um, uh, and to provide freedom in its broad sense for your people. Well, then you have that's the story of the Caribbean Court of Justice. If you want a court that is going to lean or hold to particular precedents and particular very strict literal approaches to interpretation. Um, that's the role of the Privy Council. So you choose which who do you want to tell your story, and sometimes if you think about it, that it allows us to kind of break down the complexity of these judgments and all the Latin terms and things, just think about it. Judges are storytellers. They are narrators. They're some of the best novelists never to win Pulitzer Prizes or Nobel Prizes in literature. But let me tell you, there's nobody that can write a story like a judge because that's all they're doing. They're essentially trying to craft a narrative to sell or to fit whatever judgment or principle they want that they want. We can always imagine it's a noble cause and it's all about the principles. Yes, it is, but in a very practical, literal, sense, they're trying to decide, okay, I want an outcome of this. I have to tell the story that is most convincing to my audience, which is us, the lawyers and the academics, the court, the jury, whatever. That gets me to that point.
Okay, that was quite an interesting discussion that I just listened to. What I will say here, because you kind of answered the next question that I was going to pose to you, Ronnie, so I will not ask that question because you covered all the aspects that would have been related to that. So I think we could have a brief discussion here because it seems as though that you and Alex are in agreement with the majority position coming from the CCJ. What I will have to say here is that I actually agree with the Privy Council position, and I agree with the dissenting opinion of Justice Anderson in Nervais. Now, before I say why I agree with them, I do want to say that there is another issue that you raise where I do agree with you. So I will start with that first. Now, you said that the Privy Council, in cooperation of Hamilton, which is the case that we're here discussing, they essentially laid down the gauntlet and they stated their position in a very matter-of-fact way, without much, deep philosophical reasoning or anything like that. And it really took my mind back to the case of Chandler, where the Privy Council also disagreed with the CCJ on another important constitutional issue, which you alluded to a few minutes ago, which is the savings law clauses and the effect of savings law clauses in Caribbean constitutions. And when you read Chandler and you look at this Privy Council's reasoning, it is a bit undercooked and it lacks intellectual rigor. And I know that may sound a bit harsh, but that's the best way I can put it. And there's no deep, solid analysis in that judgment. The Privy Council essentially said, just like they did in the Corporation of Hamilton, that we have a long line of precedent saying that this is what the position this is what the position is on savings law clauses, and therefore, unless there's something fundamentally wrong with our precedent on that, we are not going to depart from it. That was their reasoning, essentially, for the most part, and that was it. For me, that's not good enough. You can't say just because you have, let's say, decades of precedent on a particular issue that you are not departing from it full stop. It has to be much deeper. It has to be more solid than that. So it is no surprise then that for Corporation of Hamilton, where they're looking at another constitutional issue that is so highly controversial, that they adopted a similar approach in terms of reasoning. It seems as though that's just the modus of the Privy Council generally. And was also quite interesting about Jay Chandler from the Privy Council is that, like I said, is a case where they disagreed with the CCJ on another important issue. And interestingly, in Nervais again, Nervais is the case that has a lot of controversies where Caribbean constitutions are concerned. In Nervais again, Justice Anderson, same president of the CCJ, he also disagreed with the majority in relation to how they approach savings law clauses, right? So it's very interesting that you have the now president of the Caribbean Court of Justice agreeing essentially with the Privy Council's approach by and large in relation to constitutional issues. And then you have the majority of the CCJ saying something completely different. Now, even though in Nervais, Justice Anderson arrived at the same decision that the majority did, he took a different route, essentially. And the route he took was that was a different route that the Privy Council also disagreed with, but by and large, Justice Anderson and the Privy Council were on the same page. So it's just quite interesting to see how, in relation to all of these constitutional issues, the president of the CCJ seems to have a completely different view on certain things where constitutional law is concerned. Now, where I disagree with you, Ronnie, and let's have a brief discussion here. We're talking about the clash of the courts, but now you may have a clash of the academics, the clash of colleagues. You must admit, though, right, that there is some merit in Justice Anderson's view and the view of the Privy Council, where they're saying that these opening sections are preambulatory in nature, they're introductory, and therefore should not be enforced. And I say that for two reasons. Now, the same opening section, as Justice Anderson highlighted, it would say that the subsequent detailed provisions are to give effect to the rights in these opening sections. So that is a clear, unequivocal intention of the framers of the constitutions, that is not this opening section that we're now starting off with that will give protection to the rights of the individual, but is the detailed section outlining these rights that will do that. So therefore, it's clear that the intention was not to have this opening section enforceable. Now, secondly, and I always tell my students this, because this is a very interesting discussion we always have when I'm teaching Commonwealth Caribbean human rights law. Students love this discussion about the enforceability of opening sections, and the same way that we're having divergent views here, they're divergent views in the classes. Now, I always tell my students, you cannot read opening sections in isolation. You always must read an opening section conjunctively or in conjunction with what we call the redress clause, which is the clause in the Constitution telling you that you could seek relief before the High Court or the Supreme Court for any infringement, or whether actual or potential, of any of your rights outlined in the Bill of Rights. Now, why I say you have to read the opening section and the redress clause together is that essentially that is where the controversy stems from. So when you go to the redress clause, the redress clause would usually tell you which provisions in the Bill of Rights were intended to be protected or enforced. So let's use Barbados as an example. Barbados, again, opening section is section 11. The redress clause says that you can only seek redress for any breach of your rights in sections 12 to 30. Now, obviously, lawyers may not be good at maths, but this is something so straightforward. It's not rocket science. 12 to 23 excludes section 11, which is the opening section. So then how do you blatantly ignore the clear, again, unequivocal language of the framer of the Constitution to say, well, and this is what Justice Anderson was saying. He was essentially saying, well, structurally, it doesn't make sense within the grand scheme of things. Section 11, there's no way it could be enforceable because it is, without a shadow of a doubt, excluded from the redress clause, which the redress clause also called the enforcement provision, meaning that the redress clause tells you specifically which provisions or rights will be protected. So how can we make something enforceable when the enforcement provision itself excludes that? Is that not judicial and legal gymnastics? So it's like there is some merit to it. The same way is one thing to say, Ronnie, that if it is that the framers didn't want it to be the opening section to be enforceable, they should not have put it in the Constitution. But the flip side of that, if we use the same reasoning, is that if it is that they did want it to be enforceable, they would have mentioned it in the redress clause or in the enforcement enforcement provisions. So taking Barbados as an example again, if they wanted Section 11 to be enforceable, they would have said, if you want protection for any of your rights in Sections 11 to 23, you can seek redress from the High Court. But no, instead, the framer said anything from 12 to 23, which again is a clear indication and intention that Section 11 as an open section was just meant to be preambulatory and nothing more. So that's my argument, and that's why I agree with the Privy Council. That's why I agree with Justice Anderson's reasoning. And to fortify that, what I would say, Ronnie, is that I know we look at the Constitution and we say that it's different from ordinary legislation and ordinary statutes, and it must have its own unique principles of interpretation. But so we speak about the living instrument principle, generous interpretation, all of these things. But I go back to the very solid reasoning of, I think it was Lord Hoffman, I may be wrong, but one of the former law lords, I think in Boyce and Joseph from the Privy Council, where he said, it's okay to use these principles of generous interpretation and living instrument principle and interpreting the Constitution in conformity with international law obligations, but you cannot use all of these principles, drop them in a pot, a jurisprudential pot, and stir that jurisprudential pot to make the Constitution mean something that it clearly does not. All right, so there's a limit on the extent to which you can apply these unique constitutional interpretive principles, and I stand by that, right? So I know you may have a lot to say in response to that, but let's hear how you address all of what I just said.
Okay, so where do I start? Where do I start? I just feel that you set me at this whole podcast, you know. This will set up. Where do I start? So let me just say, I think you have to firstly appreciate what preambles are about. I think if you if you if you do not appreciate the purpose of the preamble, then you stick to a very strict literal context of what you just explained. You know, Section 11, yes, it is not in the redress clause, but Section 11 clearly is articulating principles that are important to the Barbados Constitution. So nobody can tell me when Section 11 says, whereas every person in Barbados is entitled to rights and freedoms, and mind you, the Bermuda Constitution says something similar. Rights and freedoms of the individual, that is to say, whatever his race, place of origin, political opinions, but to respect rights and freedoms and others for public interest to each and the following, namely life, liberty, security of person, and it goes down, protection of the law, freedom of conscience. That these are things that you can ignore. That these principles that drive our understanding of humanity and human dignity that can be set aside on the basis of technicality. That's the first thing. The second thing is, I think, to appreciate that preambles are opening statements or whatever we call them, have particular functions. They can serve interpretive functions, and they can be used as an interpretive tool to bring life, as I said, to the substantive functions. So in that way, they do not have separate or independent justifications. They're not independently justifiable. So they just serve that function to help bring life to the more substantive parts of the Constitution. And I think perhaps it depends on where you come from in terms of your law, because I don't even see that this should be a debate. And maybe that is somebody coming from a WTO background where I've seen this idea about the preambles to Article 20. Anybody who does trade law, when I say Article 20, you know exactly what I'm talking about. The chapeau, and then you look at the preambles to the WTO agreement and whether they gave context to the WTO and whether they gave color and shade and these are the kind of terms that were used to the entire agreements. So in my mind, I can't I don't even see this debate because I think those preambles help us to situate and to contextualize the actual law that is there. In some ways, I guess it's been the Caribbean Court of Justice and Joseph Boyce, Justice Witt, was just watching his colleagues who are common law trained uh, um, twist themselves up trying to justify why oh God, treaties that were not signed could have effect. And then they came up with this idea of legitimate expectations. And he's looking at it as an international lawyer from a monetary system thinking, well, I don't see the issue here. While they're coming from a common law tradition of dualism, going like, there's so many things here. So sometimes it may also be the background of where you're approaching these things. Are you a civil lawyer? Are you a trade lawyer? Are you a common lawyer? Um, a common law lawyer? And for me, I just can't see why this is an issue because preambles or these opening statements have that ability to provide interpretive function. They have that ability to give context. The other thing about preambles that we have to appreciate is that they can fill lacuna. They can help us appreciate where there may be gaps or there are things missing from the substantive law. They can come in to help us shape and understand that. They can come in to help deal with issues that the framers may not have considered because they weren't issues. So preambles can have some these very broad interpretive principles. For example, let's take this about climate change. All of our constitutions were designed, climate change is obviously not mentioned. Some of our constitutions barely mention the environment in any detail. And if they do, sometimes it's mentioned, guess where? In the preamble. There's no judge, I think, without who has any nuance with a particular case who is creative enough that could not use those broad environmental principles in our preamble to give life to our constitutions to address modern day climate change challenges. Because that's the whole point of constitutions being ever living. You can't draft a constitution to think about everything, but when you have principles that are broad enough, that's the whole point. The principles usually allow us to shape out and to reach for things that we may not have thought about when the constitutions were originally drafted in the 1960s for most of the Caribbean. The other thing about preambles, which I think we have to appreciate, is that they are they can allow us sometimes to draw in other forms of law. So I know I mentioned the rule of law point, but it's a big point. We always talk about rule of law, but sometimes there's no specific provisions. And the preambles sometimes that's where those provisions about rule of law are expressed. But there's nobody that would dismiss and say, oh, because rule of law is not mentioned any detail in the Constitution, that it's not applicable or justicable principle in our Constitution? Of course not. You know, I would like to hear anybody tell me otherwise. Well, of course not. So if you make the argument that things like rule of law, things that don't have clear articulated principles are justicable, separation of powers. I would like to somebody tell me that separation of powers is not a principle that we can, of course not, that we can use, but they're not clearly articulated in that way. How do we dismiss all of these principles on the basis that, yeah, because it says from section 12 to 24? Of course it says from section 12 to 24. I think we can respect that section 12 to the 24 in the redress clauses, but at the same time, draw on the preamble language to give life and meaning to what may be in section 12 to 24 without dismissing that section 12 and 24 are specifically applicable. So I don't think anybody, and I think we can do both. And I think that's important for the context of the Caribbean and what we're trying to do with our decolonial constitutionalism. I think that's really important for us sometimes to recognize. And I think you were right, Rico, when you said that the constitutions have to be interpreted differently. They're sui generis documents. So we have to take that approach that we have sometimes to give approaches and life to them because what they're trying to do is bigger than what ordinary law would do. They're trying to establish, I'm gonna draw in Macintosh here. They're trying to establish a blueprint for the way of life of a political community. And when you think about constitutions in those big, broad terms, they're powerful instruments. And we cannot see an instrument that is so powerful to provide the life of a political community and then be denying certain sections or marginalizing groups based on technicalities when the principles have been established for that community.
Okay.
I mean, I also would like to add, just because I think from my perspective, why I think the CCJ is correct, to build on what Ronnie was saying, is that opening sections sort of lay the foundation for the deeper structure or the inherent values of your constitution. And the reality is that the way many of our constitutions are drafted, if you take the position that these preambulatory provisions have no legal effect, what you are doing is you are now preventing territories or countries from accessing the deeper, more philosophical aspects of having a constitutional supreme state, because now you can't look at protection of law in the broad conception that the My Alliance case has articulated it. You're limited to what your constitution says protection of the law means. Like in the Hamilton case, the protection of the law was limited very narrowly to a person's relationship with the criminal justice system. Even in the right to property, which is also something that was raised in the Hamilton case, your right to property is now limited to a constitutional taking. And we all know that your right to property has been developed expansively across the jurisprudence across the world. And I think that is, to me, that is why these opening sections are important, because they lay out ultimately aspects that form the core of a constitutional state insofar as it relates to rights. Your right to life, liberty, your right to property, and your right to be protected by the laws of the state, right? And those things are not meant to be static. And I mean, the CCJ did address the point you were raising with respect to section 24, the redress clause in Nervais, where they indicated that the without prejudice section of section 24 did not preclude bringing an action under section 11. And I think what I would add is that in Hamilton, there's no provision like there was in Nervais that specifically said that section 1 is not enforceable. So I think, just to build on what Ronnie said, I think it's important to look at the practical consequences of taking the approach that these quote unquote preambulatory provisions aren't enforceable, because calling them preambles sort of concedes that they're preambles. They're actually opening sections. And I think when you refer to them as an opening section, you now couch it in a term that, to me, captures what it was intending to do, which was to provide some form of structure to how we interpret rights.
Okay, quite interesting, Alex. So you both said a lot there. I have a few things to say before we move on to the the next question. Now, I will address one thing that you mentioned, Alex, in relation to the majority opinion from Nervais, CCJ opinion. Now, to my mind, the majority's assessment and analysis as to why the redress clause, section 24 of the Barbados Constitution, still allows the opening section, section 11, to be enforceable was quite tenuous at best. At best, it was quite tenuous. What you just mentioned in relation to the without prejudice, I mean, come on. We all know, and you are a big fan, Alex, of he's now justice because he was appointed as judge of the CCJ recently, Justice Arif Balkan. You're a big fan of him. We all know that those words without prejudice in the redress clause have absolutely nothing to do with opening sections. The words without prejudice mean any other legal action that you can take outside of the Constitution. So then it can't then be referring to the Constitution itself.
Rico, how does that reconcile with the
No,
provision just underneath it that says that there's no other available legal remedy? Right.
That's essentially what I'm saying. And it goes on to say, and the implication is that it's speaking about any other available legal remedy outside of the Constitution, which we have that is why, Alex, we have the parallel remedies principle, also known as the adequate alternative remedies principle, anything outside of the Constitution. And Justice Balkan himself, in a Belizean case recently, Court of Appeal decision, made that quite clear where he relied on the same words without prejudice. So it doesn't apply to the Constitution, but it applies to any alternative available remedy outside of the Constitution. So that when the CCJ relied on those words without prejudice, I think they were not simply reaching, as Ronnie said, and this goes to the point that Ronnie made. There's a difference between reaching and overreaching. And when we can look at the clear words of the Constitution to make it mean something that it clearly does not, then that is where we then go into the area of overreaching. It's fine to say that we can reach, but when you're doing something like this, where you're making opening sections that were not meant to be enforceable, then where do we draw the line between reaching and overreaching? And my final point, Ronnie, is that you mentioned different ways in which we can perceive or utilize opening sections. And then Alex also said something that caught my attention, which is that the opening sections lay the foundation. And when I really think about it, even though it may seem on the face of it that we are in disagreement, and when I say we, you and Alex against me, the reality is I don't think that we are. Because the language that you all use seem to suggest that we have a common understanding when it comes to something, and I'm going to explain what that thing is. Now, Ronnie, you mentioned that preambles can be interpretive aids, and they could essentially breathe life into the substantive portions of the Constitution, which is something that I can accept. I can fully agree with that. And as a matter of fact, we all know that is what the CCJ said in Joseph and Boyce. Now, there is a difference, though, between using the opening section or a preamble as an interpretive aid and making it independently and separately justiciable. I have no problem. Let me just make that absolutely clear. I have no problem using an opening section or a preamble as an interpretive aid because I think that's absolutely necessary. But I do have a problem when you're going to go as far as to say that now it is independently and separately by itself justiciable, meaning that you can enforce the rights in a freestanding manner in that opening section. The position of the CCJ, the majority, is that it is separately enforceable. That is what I have a problem with. If the CCJ had said that we're using the opening section as an interpretive aid, Rico would not have had a problem, you know. Rico would not have had a problem. Because I think that, to be quite honest, some of the same outcomes you achieve by saying is separately enforceable when it clearly was not meant to be, you can achieve by using it as an interpretive aid. And that's all I have to say. So you all can tell me if we agree or we still disagree.
But what a mighty sparrow said 10-1 is murder.
Yeah.
you know that I will come with my references. Look, I think that our destination is the same, but our reasoning is different, which makes the destination, I know it sounds weird, but which makes the destination slightly different. So if three of us were judges on a case, we would probably get to the same outcome, but the way and the reason of that outcome will be very, very, very different.
So then Ronnie, you're likening this then to the CCJ panel in Nervais, because that's what, that's essentially what happened with the majority and Justice Anderson. They all arrived at the same outcome, but the path that they took it was different. So that's quite an interesting observation.
And I think the reason for it, and it's something that we don't give enough thought to, is that we're starting from different philosophical foundations. Not that we're not all believing in decolonization of the Caribbean, creation of Caribbean jurisprudence, all that's fine, but at a fundamental basis, we are thinking about the law differently. And I think that's the problem. We often assume that everybody's thinking about the law in the same way. No, we don't. We are obviously in our background, or if you want to put it, our mood music for the law is different. What is playing in my background for the law is very different to what's playing in your background, Rico. And I think we have to, if we want to understand more why we come to these positions, we would actually have to have a discussion on what the philosophical basis that drives us in the law is. And that's where we can point out where the difference is. And sometimes that's why in the CCJ, the Caribbean Court of Justice judgments, I really appreciate what Justice Jamadar does. And I'll say why, and I'll bring it back to this, because you can see his mood music. Sometimes you don't see it for the other judges, but it is clear where his philosophy is. So you always can see where he's going and why he's going to arrive at that destination. You don't have to agree with it. You may think, actually, I would play a whole different tune. You know, I definitely would be doing something different, but you know where he is going. For me, I think why I don't see a problem with this. I can see why you see that there's a contention about the separate enforceability of it. And I agree with Alex. If we think of them as opening statements and not preambles, because they don't label themselves as as preambles per se, but you know that's the language that's been built up around them. If we think of them as opening statements, then that may change the way that we approach them, and we can understand that they may have enforceability outside of the other detailed provisions, because these provisions are too you cannot ignore the detail when a provision will talk about life, liberty, and security of the person and protection of the law. It's almost impossible to ignore that as a substantive articulation of a legal principle and doctrine. You can't tell me that if a case comes before you and you have to reach into the Constitution for protection of law principle or for whatever principle or privacy of the home principle, or that you won't reach into there. You know, for example, if you use air services, the concept of you know, that you should consult. We know that, for example, our constitutions some beyond Guyana don't have very detailed articulations about public consultation. But we know generally in their preambles, they always talk about how the people should be heard and the people have a voice and they're the sovereign, et cetera, et cetera. And actually, if you are a good judge, you can use that to argue a basis for consultation with your citizens without the detailed articulation of the Constitution, because you've articulated it. It's there. It's how do you develop it? Because perhaps when the Constitution was written, the concept of this public consultation was not clear. Now we are more mature democracies. We understand that the people need a say. How do you give them a say in that Constitution? That brings us to your point, Rico. When are you crossing the line when it comes to how judicially active are you going to be in creating these laws? I don't have an answer for it. I really don't know when, because it depends on the context, it depends on the case, um, and it depends on what is Parliament doing. Is Parliament uh, being active in terms of changing the law? Because we know it's not as if you have to wait for Parliament. Well, nothing happened. But at the same point, we know, should judges be stepping into this space to take up these roles? That's
Exactly.
debatable. That's
Exactly.
debatable. That's a hard one. But at the same point, if a case comes before a judge, it's not like you can't send them back. You can't exactly say no. You have to do something. And if the principles are there, and I guess this kind of even comes back to Dworkin and Hart, this idea of law and principles, and principles providing room, to fill the kind of, and all these things, because principles kind of, if you like, um, provide the way to apply the actual law. So I get Justice Anderson's position. I can see from a clear doctrinal, literal, let us just read the words of the Constitution without how to put this. This is just read the words on the page. What do the words tell us? They tell us that these sections are pretty much, when linked to the redress clause, they have no force. That said, as Alex mentions, the Bermuda Constitution doesn't have that. So that was even so. It's interesting how the Privy Council was trying to use the arguments and Nervais to deal with what they were doing in Hamilton. I guess they were using the broad principles, not the details, because when you scour the Bermuda Constitution, it doesn't have that same redress clause section. It has the beginning section, and you guys can correct me if I'm wrong, but that's what I am. That is what I am seeing. It doesn't have that section. So
Yeah, I checked. It doesn't have it.
yeah. So it comes down to, all of this comes down to, I think, what is our philosophical basis? How do we approach and interpret the law? And if you go with what the CCJ tells us, it tells us that you have to do it from a basis of context. They tell you that when you read Smith and Selby, they set out their approach to interpretation. It was very clear that context is needed. They so I'm not, I don't know. I don't So you have to you just can't read the words on the page. The words on the page only make sense within what is the context of what is this constitution trying to achieve? What is this country trying to achieve? And I think that's probably the approach that the majority takes. Not that I think the minority in dissent opinion is not taking that approach, but I think they are more guided by, as you are, Rico, by this clear idea of separation and the literal meaning. And when you put them together, you're like, actually, that's the role of the parliament, that's the role of the court. What does the law say? Okay, I've interpreted the law, this is as far as I can go. I would love to go further, but until there's a basis for me to go further, I don't believe that I should go further.
Okay, quite interesting, Ronnie. There's so much that you said that I would like to respond to, but in the interest of time, we have to proceed. But I do agree with some of the points that you you made. Quite some interesting observations, definitely. And I will say that this discussion reinforces my view that we really should have a for and against paper on this particular issue, because I think it would be well written and reasoned, exciting piece, definitely. So what we're going to finish off with, Ronnie, is we're going to ask you about the practical consequences of this disagreement between the Privy Council and the majority of the CCJ as it relates to the enforceability of opening sections and the road ahead. So do you think that the decision in Corporation of Hamilton strengthens or undermines the argument for moving away from the Privy Council as a final appellate court for some of the Caribbean countries that still utilizes it? And could we see the CCJ gaining more traction because of this?
Um, I think, uh, and not what do they call it now? What do people call it? Not self-selling, but I think the paper that I did, and actually, the paper that you did recently, Rico, which seems to support the view that you know there is value in these preambles. I'm not going to use your own words against you.
It may have been Alex's words because he was a co-author.
Well, when you co-author, you don't differentiate who. So it's both of your words where you talk about the fact, you talk about the charter of CARICOM Civil Society Charter, and and that being preambular, if you like, not being justicable. But then you talk about it, adding value and use words like invoking the soul of CARICOM, because how could you have something so fundamental setting out it's supposed to be rights and articulating the vision of the people, and then you go, well, actually, you know what, this makes no sense for you have no force of law, which is the same thing that Barbados did when they did when they were reforming the republic. They came up with this charter of expression of rights. And you're like, well, but then what's the point? Would you express it? But the moment that you write that down, I would hope any sensible political person or aspirant would know a good judge or a good court will reach for it. So you better don't put anything claiming non-justice just because. I think that's the problem. Just because a parliament says it's non-justifiable doesn't mean the courts have to pay attention. Because if the courts see that there's a principle or there's something, the courts can use it. And all the cases have proven my alliance, McEwen, Nervais, Joseph. I mean, and it's not only the CCJ. We're behaving like if the CCJ is the only court doing this. I mean, we could go back to the beginning of the European Court of Justice. I mean, those guys used to just create principles, subsidiarity, all kind of things. You just pull from literally pulling them from thin air. Like, I mean, we could go back to principles about common law. Some of the biggest principles in common law are literally pull from thin air. Because the reality is judges will make law. They will do these things and they will use the available um, principles, however they're articulated, where they're articulated. So, that's why I thought your piece, looking at the charter and the case that is going to be before the Caribbean Court of Justice in its original jurisdiction is going to be interesting because they're going to be called upon to basically decide if the charter has some kind of legal force. And it will be interesting to see what the court does. Given what the court has done in all of the cases that we've talked about, I don't see how the Caribbean Court of Justice could say that the charter doesn't have some kind of force. I would love it, it would be beyond me to see what kind of arguments they could use to say that the charter doesn't have force, because if they do that, they're going to be dismissing, in my mind, all of what they've done. And then you're going to have, which will be interesting because then you're going to have almost like the two minds of the courts competing against itself. The court in its original jurisdiction and the courts in its appellate jurisdiction. So not only do you have the a differentiating, not only different judgments between the Privy Council and the Caribbean Court of Justice, you may have, if they don't follow what they've been doing, you may have the Privy Council, the Caribbean Court of Justice as original, and the Caribbean Court of Justice as appellate, which would be even more interesting for one small region, and you're getting multiple and variant approaches on the same issue, emanating from maybe the same court on one side and a different court on the other side. I don't think that this case forms any kind of rift in Caribbean jurisprudence. What I think it does, it should be a signal to those who have not joined the Caribbean Court of Justice that they need to avail themselves of the Caribbean Court of Justice, because the Privy Council is clear about its direction. The Caribbean Court of Justice, to this point, has been clear about its mission and its direction, and you have to make a decision of which court you think is going to tell your particular story as a decolonizing nation, because that is what we are. We are what, 60 years, maybe 50, 40, depending on the country, sometimes removed in terms of independence. So we're not very far. The Caribbean Court of Justice has been a powerful symbol, and also in very practical, real terms, in creating jurisprudence. The fact that we can sit down here and discuss all of this, and this is what, 20 years is nothing in the life of a court. That shows you how much intellectual output and energy and creativity have gone into these judgments and what the Caribbean Court of Justice is actually doing. So I wouldn't bank on it or term it a rift, or like, the sky is falling. But at the same point, I think the case does indicate that we need, it's a signal again to look at where you are for the countries that aren't part of it, and maybe we have to make that hard decision. So I said, I'm often concerned about how we frame the countries that remain out of the Caribbean Court of Justice, and we have to be careful with our language. I don't think that the people who remain are silly or don't understand. I think sometimes people may have genuine fears about what they think about courts or what courts are doing, and we have to kind of address those fears and calm them and walk people through the process and explain to them the role of the Caribbean Court of Justice and the role of the Privy Council and what access to justice means and what does it look like. What does the case of Hamilton looks like versus a case of Nervais, and all of these things, and to ease people's fears. But I think sometimes, and it's a fault of maybe our own academics and our own what I call symbolic capitalists. What we, in terms of dismissing these fears of the people and say, what, they should get your act together, get on board. And it may not be that simple. People have fears. They may not be yours. They may not be mine. We have all sold on and bought, and we've signed the line for the CCJ. We understand its mission clearly. We are part of a growing, emerging group of scholars. If you think about it, we would have come into scholarship, if you like, post CCJ. So the CCJ is a court that we know. In some ways, we don't even, the Privy Council is something we look at. If you think about our age and think about our practicing of law and academia and writing, we look at the Privy Council almost historically. We would have never had to butt up against its judgments per se. For us, it's almost like a historic artifact. Whereas, and for newer, think about a whole generation of new Caribbean scholars and practitioners in certain countries, knowing only the Caribbean Court of Justice, or not even that, but knowing of the Caribbean Court of Justice compared to to older generations of lawyers and judges who would have know nothing except the Privy Council. So those are the kind of real fears that we have to address, and sometimes we don't even see it that way. But we have to unpack all of those things. There's so much at personal level that people are bought into things and the psychology of it. And I really think we have to kind of regroup and think about how do we get the rest of the Caribbean countries on board with the Caribbean Court of Justice so that we can continue, not complete, continue this decolonial mission that the court has set and that we're all on. Because that's why we're independent countries. That's why we're talking about republicanism. That's why we're talking about constitutional reform. All of these things are part of it.
Yes, Alex, anything you have to say?
No, I don't think there's much I could add to that.
Yes, and I fully agree with you, except that I like how Ronnie Alex casually used our article against me to make our followers and listeners believe that I have cognitive dissonance. But
I never said you did. I
I,
never said you did.
but I will use what he said early on in this episode against him by saying that if our followers do think that just like Ronnie said, judges are entitled to disagree, and if they can do that, so can I. So they are entitled to disagree and change their mind. So if judges can change their minds, I can also change my mind. But but I want to say though, Ronnie, that this was certainly an enlightening discourse. Thank you very much. I'm sure that you shed a lot of light on many things touching and concerning this one particular issue for our followers and listeners. It's always a pleasure to have you as a discussant, a guest, a panelist, whatever. You do add tremendous value to any academic discussion, any discussions that are non-academic. It's always just good to hear your views and to hear your opinions. So I want to thank you very much for coming. Thank you so much for your time, because I know that you're also a husband, you're also a father of two now, and you're a deputy dean and a senior lecturer. So I'm sure that you have a lot of student emails to respond to as well. So the fact that you actually came here to just spend I can't even say a few minutes because it may almost be
So almost 2 hours.
almost 2 hours now. The fact that you came here to spend almost 2 hours with us is quite telling, and it shows a high level of dedication to ensuring that public education and public legal education goes a very long way. So thank you very much, I'm Ronnie, for being here.
And thank you very much for having me. I certainly enjoyed it, and it doesn't feel like 2 hours. I feel like we're now getting into a discussion. I mean, we've got
Exactly.
so much road to go.
This is actually why Rico and I started this podcast, because we realized we spent so much time during the week having these discussions that it was not very productive not to record them.
Exactly. So now we have a lot of subscribers, we have a lot of followers, a lot of listeners, people who support us that can actually now be a part of these discussions when we actually turn them into episodes and publish them. So guys, that has been another episode of the Public Law Parlour. We hope that you enjoy this discussion whenever you get a chance to listen to it, and look out for the next episode that will come. Thank you once again. Until the next time, we bid you adieu.